Today, we are in conversation with Canadian lawyers and mediators renowned for improving access to justice. Can a values-based model of dispute resolution with more negotiation and mediation accelerate access to justice in a pandemic? What is changing and where are we headed? Welcome, everyone.
Thank you.
Today, our panelists are mainly from the Ottawa region, and Mary is from Montreal, but Keith Gordon unfortunately was unable to be with us today. He is in court. So we have with us Len Max, barrister and solicitor in Ottawa. Len?
Hi.
Eliane Lachene, personal injury lawyer in Ottawa. Welcome, Eliane.
Good morning. Good morning.
Enoch Anekwe, family law lawyer in Ottawa.
Thank you, my pleasure.
Mary Damniakas, international mediator in Montreal.
Thank you for having me.
Alison Campbell, family law lawyer in Ottawa.
Good morning. Thank you for having me.
And Ernie, the attorney in Ottawa. He's our host today. Welcome to the panel.
Thank you.
And I'm Doreen Kahali with Global ADR Strategies. We're going to get right into the content. So panelists, what are your takeaways from our conversation with Justice Colin McKinnon, Queen's Counsel, retired from the Ontario Superior Court bench in 2018? Let's begin with Alison.
Thanks, Doreen. It's actually fairly difficult to come up with sort of a takeaway to speak on because there was so much material and there was a lot of insightful comments in that session. I think what I took away from it, and mainly because it spoke to me, is there was a comment about how do you sort of reconcile mediation and litigation mentalities and process. I am a high conflict litigator. I'm cautious about saying that about myself because it sounds like I'm a real problematic individual, but I tend to focus my practice on high conflict litigation. I'm also a mediator and I do a lot of high conflict mediation. I'm also a collaborative practice professional. So one of the challenges I've always had is when you're in a litigation process, which is obviously very, very interest-based, very legal-based, a very legal model, which tends to be combative. How do you then say to a client, you know, let's just leave this and go to mediation? And then how do the same lawyers and the same parties who've been in a courtroom arguing at each other for days, years, how do they then sit down and go, okay, how do we settle this? And I really appreciated his honor's comments because he seems to see it as not being such a far trip, right? It's the two can work very well together. And in fact, mediation should be an important part of litigation. So I felt that was something I really took away. And I think it changed my perspective a bit, as opposed to seeing mediation as being part of a litigation outside of a litigation scenario, more of an important process in the litigation process, and that you can do two together and that you should. Certainly in Ottawa and family law, we don't have mandatory mediation. So while we do on the civil side of things. So I think that really spoke to me. I think that was the most important takeaway from me and allowed me to sort of reorient the way I'm thinking.
Thank you. Thank you.
Thank you, Alison. It was great. Thank you. Eliane.
So a bit like Alison's comments, there are many things that we could discuss. I'll try to keep it brief and maybe mention the takeaway for me, the thing that was the most relevant to the work that I do. So I work in personal injury. I represent injury victims. So my cases are often against and almost always against insurance companies. And Justice McKinnon made a comment that the lawyer has a duty, obviously, to represent their client, but also a duty to resolve the client's claim. And it's so true, right? A lot of my clients will come in at the first meeting to say, I want my day in court. Well, I think it's my job, and Justice McKinnon's comment pointed to that it's our job as lawyers to educate our clients, to explain to them what it means a day in court. And it's not next week. In civil matters in Ottawa, we're talking in 4 or 5 years from now. And I think that's where alternative dispute resolution comes into play, so we can get those claims resolved early, and we can accomplish our client's goal, which may not be to have their day in court, but to have a just resolution.
Well said.
Great. Thank you. Thank you, Eliane. Mary,
Well, I think the comments before me, both from Eliane and from Allison, sort of also resonated with me. So the mediation is it's mainstream. It's part of high conflict litigation, low conflict litigation. It's one of the processes that can be used. And I think that Justice McKinnon is just an amazing and wonderful person. And I think that kind of a personality is really makes a difference in the way he approached his job and his position, with such modesty, such humility, that it's very, very, very impressive. And I thank him for that. Yeah.
thanks, Mary. Len,
Well, I might add for starts, Colin and I go back a long time to pre-judgeship. And so I've known him for a long time, and I was, of course, very impressed with his commentary yesterday. A message that I didn't need to take from him, because in my head I already have it, but I took from him, and maybe I differ a little from my other panelists. From the get-go, from the start, from the initial interview, I think it is important to outline for your client, of course, the options as to how the case may be approached or resolved generally have to be covered. But I think that there should be the start of a push to consider mediation, and to consider it not just as a part of the overall process, but to consider whether you're in a position in that particular case to try to opt for it from the outset, and to avoid getting into litigation if you can possibly do it. That's what I took from him. And of course, that's the reason why we have professionals like Allison and whatnot available. It is very difficult at the outset, I don't have to tell you, depending on the frame of mind of your client when they come in, to sometimes approach that. But coupled with a cogent outline of the time and cost of litigation and the wear and tear of it, and an experienced lawyer can describe the wear and tear of it, if it's not already wearing and tear them completely, is something that should be reviewed, and they should be forced to put their minds to that if you can possibly do it.
thank you very much, Len.
So true.
Enoch,
Well, thank you, Doran. Well, it was a privilege hearing Justice McKinnon speak yesterday on the perspective of the bench. I've had the privilege of hearing a lot of people from the bar digest this issue in the past. And I would generally say that my take was the approach he used, which I could generalize by saying that he dissected it on the basis of regulation and obligation. And from the bar perspective, I know that we lawyers have an instinct as litigators to win. It comes naturally when every client walks into the door. Your approach is that we usually often are scheming about how to strategize to provide the best result for the client. And that comes with the very nature of our service. And often we do come across clients who are professional litigants themselves or who are very vindictive. And I do know that the Law Society has provided trainings on how to deal with such clients. I don't know if it's adequate. I cannot speak to that now. So as of January 4th, 1999, I know that Toronto introduced mandatory mediation program for certain areas of civil practice, especially wills and estates. But I don't think there has been enough study as to understand and be able to measure the results. So I think that we also need to look at the study aspect of things, because I've never seen the data with regards to the impact of the introduction. And I do know that as of 2012, that Ottawa and Windsor also introduced the same measures. I don't know whether there was a study before the introduction. I don't know where we are at right now. And we also in family law do have the MIP, which is similar but not the same. Basically, it's mandatory for every litigant to call a certain number and just generally be informed. They receive an information session on what the nature of the procedure is, and generally guide them on the obligation to seek early reconciliation. In all, from my own experience, I think that what most people don't listen to is the cost effect of litigation. No matter what we do, both as lawyers and as litigants, most people tend to be very wary of cost being awarded by the courts. And I know that the courts pay attention to offer to settles being made. So there has to be a balancing of all these issues to make sure that they all work hand in hand, so that we can have an effective system. So there is a regulatory aspect of things. There should be a training for lawyers so that they would be aware subconsciously and consciously about the obligation to seek early mediation, and in certain instances, especially in family law, to seek to maybe make an offer to settle from the onset. And I think that will bring about a better bar and the bench overall. Thank you.
The next question we have is, how do you understand the key phrase of access to justice and the roles of professionals in the all-inclusive ADR spectrum? And we'll start again with Allison.
So that's actually a question that I think we could all speak to for the better part of a day. And even though I'm a litigator, I will endeavor not to do that. I think the short form of my response would be the obligation, right? We're all professionals, we're all legal professionals. Whether it's litigators or whether it's barristers, whether it's mediators or arbitrators or parenting coordinators, we all have an obligation to present other ways to solve a problem. And, you know, particularly in family law, because I'm not in a position to speak to any other another area, I'll leave that to Eliane, who's far more experienced than I in civil litigation. But in family law, there's a very good argument that the type of communication that takes place in ADR suits families much better. And not just on a current or a dispute resolution basis, but on a go forward basis. In litigation, parties do not learn how to communicate, right? They reinforce the combative aspects of disagreement. In mediation, in fact, they learn better ways to communicate. If you have a good mediator who can move parties through a discussion, then they learn to communicate better on their own. And I think we often see on a go forward basis, families doing better if they've had the benefit of ADR. So, and again, in any form, most people aren't familiar with parenting coordination, but parenting coordinators such as myself, it's a combination of mediation and arbitration on various issues. So I think having the benefit of teaching a better way to communicate, particularly when there's children involved, is vital. So as professionals, we have that obligation. And I'm not holding myself out as a teacher, somebody who can teach people to communicate better. Rest assured, that's not my role. But certainly there's an aspect of leading people down that path, providing them with the opportunities that they can learn to do things better. So that, you know, for example, in a COVID-19 crisis, if one parent isn't following COVID-19 rules, the other one doesn't file an application with the court or bring a motion, which is going to cost a lot of money, is going to deepen the conflict. They call the mediator and they say, let's sit down and talk about it. So I think that's the role that legal professionals play. And I can also indicate just very quickly, one of the things I saw among legal professionals in Ottawa with the onset of the COVID-19 is more of a return to the old school of lawyering. In fact, His Honor talked about that yesterday, old school practice. So, you know, lawyers used to talk to each other, right? You'd pick up the phone and you'd call and say, we've got this difficult situation. Let's put aside the conflict and how do we really fix this for people? When the COVID-19 hit, the courts did not close at all, but they certainly reduced their services. And I think as lawyers, we had an obligation to find a way to make decision-making continue to be accessible to the public because of the reduced access to the courts. And one of the ways that happened in Ottawa was the Virtual Family Law Project, where a bunch of mediators, arbitrators, and parenting coordinators got together and created a website to try and make ADR come more to the forefront. So I think we've got the obligation to assist people in finding better ways. And I think as professionals, we've also got an obligation, like Ernie does, to create better ways for people to use ADR and get solutions that better meet their needs both now and in the future.
Wonderful.
Yes, thank you. Thank you, Allison. Eliane.
Yeah, so access to justice, certainly in my case, it includes ADR. There is no doubt about it. His Honor mentioned it yesterday, litigation is a burden on litigants. Not a lot of people want to be involved in the lawsuit, and certainly not my clients who have been injured. And I think it's, again, our duty as lawyers to lessen that burden. I think, again, His Honor made that comment yesterday. And justice, what does it mean? Well, I think an early resolution of a claim, that's attaining justice. And although the relationship between my clients and the person on the other side, which is typically an insurance company, are certainly not the same as Allison's clients, where they will have a long-standing relationship, I still think that an early resolution is a good result, is a positive result for my clients. But the reality of the backlog of civil cases in Ottawa and in Ontario, and the uncertainties that a jury trial can bring, ADR has to be the solution. And it's certainly, I see it as my duty to educate my clients on the importance of the mandatory mediation, or that it be a second judicial pretrial. These are important steps. And I'd like to comment, Len made a comment about the early resolution, but even before litigation starts, and that's very interesting. And I do think from a professional perspective, it's something that I need to look at more closely before we even start the litigation. Let's go and see if there's a mediator that's available so that the parties can sit down together, because some cases are quite simple and could be likely resolved that way. So thank you, Len, for I made a note of that suggestion. So for me, access to justice definitely includes mandatory mediation or any ADR.
Thank you, Eliane. That's great. Mary.
Access to justice, I think, is a really big question, and I don't know if I can answer all of it today here. But what I can say is that here in Quebec, and I know that in BC, especially with dealing with families, we have mandatory mediation. So mandatory in the way that it's mandatory to go to mediation, but of course, mediation is voluntary. So mediation is the go-to place when you're dealing with families and also when you're dealing with small claims court, and that is expanding. And it's very similar, I think, in BC as well. One of the important aspects, as I see it, within the family and small business conflicts that we are seeing now with, especially during COVID, the difficulties and uncertainties with COVID is that it's important to triage. So it's important to triage and to see which of the clients will benefit from the litigation, need litigation. There is no ifs or buts about it because there's a benefit, and some clients need to be in litigation. Some clients may need mediation. Some clients may need, if it's a family case and they're high conflict, they may need the parenting coordination, which of course is very, very challenging for anybody who's ever done parenting coordination. Family mediation cases also can deal with high conflict cases. There are techniques and there are ways to manage that. So the triage part, I think, is missing right now. And we need to incorporate more triage in our work and be able to funnel the clients to the services that suits them best. How do we do that? I don't know. I think we have a little, Quebec and BC have been a little bit ahead of the times, I think, but that could change, of course, things can change. And also what I would like to say about Quebec is that the first conference on family mediation was held in 1980. It was held in 1980 during the time of the referendum vote. Just okay, I'm not going to go into any other political discussion here. Okay, not appropriate. Okay, not appropriate. I was a student and it was back in 1980. So this is how long mediation has been in this province, and the discussions, the conversations, the policy, and it's also in the Civil Code of Procedures. So there is a very strong body that regulates family mediation here in Quebec, and also moving towards coaching and parenting coordination. So that's what I have to say. And I don't know if this is relevant in Ontario right now, and I will put myself on mute. There we go.
Thank you, Mary.
Thank you, Mary. Yes, thank you. Len?
Well, Allison echoed a lot of my feelings. We, of course, both, I don't practice exclusively in domestic law, but I practice very heavily in domestic law, but I'm also on the civil side. I think that COVID has given a real kick in the teeth to what we are struggling for here. One of the advantages, as far as I am concerned, in having access to a good mediator or judge is that it's in person. The effect is far stronger if you can go face to face. Given COVID, talking about getting somebody access to justice, given COVID, if you can pick up a phone, call your opponent and say, look, let's start off by sitting down and exploring this and see what we can do. And as far as I'm concerned, I'm prepared to go to anybody's office to do that, COVID or no COVID notwithstanding. I think that's absolutely essential as long as we're wrestling with this current situation. I find it not the same in dealing like we're dealing here with this is fine because we're all good, we're all getting along, But if we were dealing with a difficult matter, I find it very difficult, whether I'm dealing with a court or dealing with counsel, not to be able to sit down and talk face to face. And of course, there are things you can say there that won't be said otherwise, which may help to bring about a resolution. But I think you got to leap in right away to see what approaches are available to you, having regard to the other side as well.
It's very good, Len. Thank you.
Yes, thank you. Ernie.
How about Enoch next?
Oh, yes, Enoch, please.
Well, I think the most controversial issue within any legal system is access to justice. And I think that the reason why it's very serious and hard to fix is because of the many contradictions that exist within one concept. And I think that the issue of access to justice should be a topic of its own in any table of discussion, because it's deep and it needs proper examination for proper understanding. But in a nutshell, my own personal understanding of access to justice is simply equity versus equality. And it's just a question of finding the balance between the two. And I think often we miss the point. And there is no better place to think about a system that has missed the point than to think of the government of the day in Ontario. The government has cut down legal aid. And sometimes I feel sorry for the litigants themselves, especially people who are genuine before the court but do not have a proper representation and cannot stand the test of time when they're up against a very well-equipped lawyer. And it's often the case. And I see that on a daily basis when we attend the court. And especially I want to draw everyone's attention to the comment or the article released on April the 18th on this same issue by the former Chief Justice, Beverly McLachlin. She tried to digest the issue of access to justice, and she actually called it a crisis, especially at this pandemic period. And she's calling for more voices to rise to the table so that these issues can be addressed. In a nutshell, I'm going to talk about access to justice in a way that shows certain contradictions, my own personal experience, not because I do know it, but just because I just want it to be a food for thought so that we can have a comprehensive approach to the issue of access to justice. Because very often when we say access to justice, people think about alternative dispute resolution. That's a very, very important and substantial part of access to justice. In fact, without alternative dispute resolution, I believe our justice system as it currently stands will crumble. So it's essential, it's important, we do encourage it, but there are also certain instances where people choose to litigate. And it makes more sense to actually litigate. I do have a client that signed an arbitration agreement. And the arbitration agreement, despite the fact that she was represented by a lawyer, from what I was told, she signed that agreement in tears because the lawyer forced her to sign the agreement because she had no money to continue to pay for the litigation and had paid 30-something thousand and was still owing about $10,000. So she signed it under duress. And the issue played out in court that 2 weeks after the agreement was signed, the other party in the family law dispute had already paid over $120,000. And I say this because the lawyer herself told me, while making complaints about the process, that her client is paid over $120,000. And within 2 weeks of the court issuing a final order of the court on consent of the parties, he started a process that returned the case back to court. His intention was to take the case to the appointed mediator who has conducted herself in ways that are unbelievable and will not pass a smell test and has extensive communication with the other party without having included my party, my client. In a nutshell, without going deep into the nature of the case, my client is crying access to justice in court and she's seeking litigation. And she's trying to rely on a particular legislation, a regulation 13407, which provides certain conditions that must be met for a valid arbitration agreement, for an arbitration agreement to be valid in Ontario. She's relying on that. Different judges have ruled from different sides. Some recognize that those conditions are mandatory, and any agreement that does not meet the provisions is invalid. Some courts have held that there is a duty of good faith, and as such, they must engage in the arbitration. So access to justice could also mean litigation. Is just a point I was trying to make in that very, with that very explanation. Another issue with access to justice is that it's quite remarkable that the conversation regarding access to justice have slightly shifted in Ontario because the society or the Bar Association intends to expand access to justice. And according to them, that at least 70% of family law litigants are self-represented. And that the only way to make that happen is to allow non-lawyers to be able to practice in the area of family law. There seems to be very strong opposition by lawyers themselves, even threatening to sue and the rest of them, but the conversation is currently ongoing. And we all speak about access to justice. I practice solely in the area of family law. I do not know if, I've had to think deeply about this concept to understand it and to see if it makes sense in the circumstance. Some people argue that it will water down the practice because non-qualified people will eventually get into the role to provide those services. And that does not mean adequate services, and especially where it has direct impact on the lives of families here in Ontario. Some people would argue that if we lower the standard by doing that, where would it end? Others argue that it's all about money. At the end of the day, the society will have more people to regulate and more fees paid towards the coffers of the society. So there are a whole lot of argument, both pro and against. But it leaves me thinking, we all want better access to justice, but really, how do we define these contradictions, access to justice? The Law Society's argument is, we're trying to expand access to justice. Does dropping the bar, does lowering the standard actually provide better access to justice? We do understand that there is like Justice Mackinnon, Justice McLaughlin made it very express that the number of self-litigants since COVID-19 has increased by 80% across Canada. So the issue of access to justice cannot be more critical. Now, it leaves me wondering, where do we find the balance? In my own opinion, I think greater funding to institutions like Legal Aid that is central to access to justice will go a long way to help. I believe funding institutions that provide mediation and funding mediation and arbitration services would also go a long way to help. As it currently stands, Legal Aid does not sponsor arbitration proceedings. So there are many aspects of this same one topic that needs to be explored in details for a more informed debate and understanding. But generally, it's holistic. I think it needs more thought. Justice Beverly has added her own input, and I look forward to hearing from people on the same topic going forward. Thank you.
What is your experience with clients and colleagues involved directly or indirectly with the legal and court systems, especially during the pandemic? Allison?
One of the things that I've said many times over the course of the last year is during the first 23 years of my practice, there was actually very little change in court process. Certainly there was changes to the law, but the process itself didn't change. In the 2 months between March 15 and May 15, 2020, there was far more change in the court system than the first 23 years. So that would be my first comment on experience with not only litigants, with lawyers, with judges, with court staff. It has been an amazing learning curve. And I think largely positive, right? I'm not saying that the changes that were made in those 2 months aren't positive changes. They really are. But it seriously changed the dynamic of how things are done. And I think we're really in an exploring stage. I think everyone is right now to determine, yes, a lot of those changes are positive, but they really force us to turn our mind to what different challenges they create. And I think that's what I'd like to speak to, because one of the biggest challenges I've had is dealing with my own clients, sort of as a legal counsel, dealing with my own clients, not only in a litigation process, but in a mediation process or in an arbitration process. Because I think sometimes as participants in those processes, we underestimate the differences between being in person and doing things through Zoom. So in the time I've got, that's what I'd like to talk about, because I think it's an important topic. And I think the litigants, the communication between lawyer and their client is very, very different now. It used to be, I'm sitting in a courtroom, or I'm sitting in a mediation, or I'm sitting in an arbitration, and I've got my client beside me, right? So if they have a concern, they can raise it with me. Because I do a lot of high conflict, including a lot of domestic interpartner violence. About half my practice involves an element of domestic violence. So if I see my client getting distressed or that sort of thing, it's very easy to take my hand and put it on their arm. Don't have to say anything, but it's like, it's okay. Just get through it, right? We no longer have the ability to do that anymore. So when I'm in a courtroom, how am I communicating with my client? They're texting me, right? That is not as effective as having my client lean over and say something to me in a courtroom. It's the same in a mediation, right? We can get into breakout rooms. And quite honestly, what I usually say is, if you need to talk to me at any length, let's go to a breakout room instead of doing this while we're supposed to be paying attention. So it creates a lot of different dynamic in how lawyers have to relearn how to do that process. And, in mediation and arbitration, we're now not all together, right? So in my area of law, in family practice, I used to know who was in the courtroom with me, because I could look around. I'd look in front of me, there's the court clerk, there's the reporter, there's the judge or the master. Sitting over to my left or right is my friend and their client. I no longer know that. So if I'm in a mediation or I'm in an arbitration, I'm looking at a set of faces in front of me. Right now, I'm looking at 8 panels that have all you lovely people on it. But I have no idea who's sitting across the table from Ernie. I have no idea. Maybe Enoch has, maybe I'm doing a mediation and Mary and Enoch are the participants. Maybe they're together. Or maybe it's a circumstance of domestic violence, and my client is sitting the room beside their partner. So to me, things were actually much easier, aside from the transportation and the management issue, when we're all together, because it's much easier to address those concerns, right? Because in a mediation, I could have my client stand up and show me the whole room they're sitting in, right? Doesn't make a darn bit of difference 10 minutes later. And if we're dealing with children, we now have a circumstance where, the children are in virtual school right now. So I'm trying to mediate a very high conflict parenting, and all of a sudden there's this little face looking at me on the screen. It's like, oh, it looks like so-and-so has joined us. So, there's a real learning curve. And I think it's taking us a long time to get there, because they don't necessarily occur to people who don't do it all the time. I have also found it very exhausting to do virtual work, because I've learned I'm not as good at reading cues on virtual, right? If I'm in a courtroom or if I'm in a mediation, I can see my client start to, get up, or I can feel the level of conflict start to build. So I think we have the ability to sort of deal with that earlier on, and maybe we can prevent the blow up, right? So in a mediation setting or when I'm doing Zoom, I don't catch those cues as quickly, because I don't think we have the same level of eye contact, mainly because people are looking at their camera, or people are looking at who's talking, or we just don't have the same connection. So I think there's been a real learning curve. And I think, because I'm not able to catch those cues as early, there can be a bit more conflict, right? So I think many of the individuals that I've talked with, whether they're lawyers or participants, have raised a lot of these concerns. I've had a number of discussions as well with professionals in the domestic violence community about their concerns about how you deal with those additional, who's there, or if a participant, when you've been married for 20 years, every single cue to annoy your partner, right? I can set my husband off in 10 seconds. I try not to do it, of course, but I can. And it's, as a mediator, you don't catch those, right? Because you may be looking at the other person where the person across the table is doing this, right? So I think there's a real learning curve, and I think we have to pay more attention to that. I think there needs to be more training, not just with regard to domestic violence and mediation or arbitration, but with regard to the procedure behind that, right? And how you set up those processes so that they provide a safe space for the participants. So it's a sort of a different access to justice concern that, we didn't have before. Is it easier for people to mediate? 100%. You call your mediator, you all jump on Zoom and off you go. But there are things we never had to consider before. And I think we need to take some time, and I think we need to do that. Otherwise, we run the risk of mediation or arbitration not presenting the safe space that we want it to for people to resolve. Thank you.
Well, that's a wonderful contribution, Alison. Thank you very much.
Yes, thank you. Eliane?
I'll be very brief. I see that time is flying.
You don't have to be brief.
No, we can do a little extra. No worries.
Thank you. For me, when I think of changes during the pandemic and the legal system and access to justice for civil matters in Ontario, and specifically in Ottawa, is that there hasn't been one civil jury trial in Ottawa since March of 2020. And let's be clear, there was a backlog before. We were scheduling trials 2-3 years ahead of time. And now we've have 14 months with no civil jury trials in Ottawa. So that is highly problematic because these are cases where the alternative dispute resolution these that it be mediation, they've been exhausted, right? So I have clients who have been waiting for trials and these are not taking place. So that is a significant issue. The Ottawa courthouse just does not have the physical space to accommodate a jury trial. I should not say that because there have been some criminal jury trials, but we have limited space and it's been reserved to criminal matters. So that is a significant problem, but I think it goes hand in hand with the ADR and making sure that all the options have been exhausted because maybe they haven't. So that's something that is important to me and to my clients. I know that the OBA, the Ontario Bar Association, has recently put together a working group, and they looked at the changes to the legal system as a result of the pandemic. And they published their report, I think last month, or it may have been in February. And there is a section on access to justice. And it's interesting because they also talk about access to justice from the perspective of all the players. Because I have to remind myself that what is more convenient for me during the pandemic, that it be working from home and attending, several meetings or sitting in front of my computer at 9:55 when discoveries are starting at 10, when that's all very convenient for me, it may not be for my client. For my client who does not have a reliable Wi-Fi connection, for example. So that report from the OBA, and I forget the name, but it talks about the future and what changes will stay and should stay that were developed during the pandemic. So it's an interesting paper, and Doreen, I can send you the link if you would like to share it with the viewers.
That
Yeah,
would be
please
great.
do, please do. Thank you very much. It was great.
Thank you, Eliane. Mary?
Well, it's been a really interesting discussion, and it's been very interesting hearing what everybody on the panel has to say. I agree with many of the sentiments that have been shared. In my personal work and working with mediators across Canada on a national level, I think with the lockdown, with the loss of work, with less socialization, health and economic uncertainties across Canada, I think we know that violence, domestic violence in particular, has been on the rise, and it is a global issue right now. It was before, but I think it's been much more magnified, and so that impacts my work tremendously. It impacts the work that the people that are new to mediation, that I'm doing supervision with, are also impacted by this. And it's really very, very challenging because we're using different platforms where we are not always able to connect with people on a personal level. And yet we still have to be able to assess, the abuse. We need to do the screening. We need to be mindful of the kind of screening that we're doing, the impact that it's having on children, on families, on parents, on elders, on the community, on the business. If we know there's a lot of family businesses that are also impacted now with the pandemic, how potent and what is the impact of the violence, domestic violence? What are the patterns? How is it impacting the community? How is it impacting the family? So it's such a huge topic. And how does it impact us? How does it impact us? Because we are working with this 24/7, 7 days a week.
Mhm.
And on a personal perspective, personal sharing, if I can do a little bit of personal sharing, is I find it really, in all my years, I'm approaching almost 40 years, and I find it now very, very challenging because it's every day and there isn't a break. And there's also a sense of lack of services. Where do the people go? Where can you send them? And so that's what I'm struggling with. And I will keep it brief because I know we've got so many other people who want to share, but that's just a little small window of what's going on with me and my work and the
So,
challenges.
Mary, thanks for that insight. And I know we only have a few minutes, so I'm going to be very brief because I know Lynn and Enoch are going to weigh in. But I had a meeting, Zoom meeting with the REACH, which is the charity I helped set up in 81 for disabled persons. And when you talk about the vulnerable, like disabled persons, like I'm doing with this Neil Coleman estate, he was a hoarder. It was awful. We have now the MAID, medical assistance in dying. The courts are now telling the legislature to get rid of the reasonable prospect of dying. I mean, it meant people mentally ill, people are disabled, people are elderly, they're all vulnerable. It's been a big part of my life. So you made me think of that vulnerable community that we cannot forget about in our system. So I know, you and I go back there in many ways, but it's kind of frightens me about what's going on under the radar. People are not paying attention to, and it's going to cause a lot of disaster. There's suicides, there's addictions, there's as you said, domestic violence, there's this incredible stuff going on. So history we will tell, but as long as we take care of one another. I love this panel. It's a panel of compassion. Okay.
Thank you. No, that's wonderful. That's wonderful, Ernie.
Next person, please.
Yeah, no, it's wonderful, Ernie. Thank you. All right, Len, the client and professional topic.
Well, I'm going to be brief because Allison again completely echoed my feelings about this problem. I don't know how all of you are with respect to following the CPD programs. They're being extensively launched online every day. But I saw one just crop up within the last week. And it's a program as to how to read your participants in a Zoom hearing. How do you read the judge? How do you read your opponents? How should you approach that? I was quite fascinated just to see that advertised. And in listening to Allison, I thought that's right on because there's a change. I might say, just before I go, I've had to argue in front of the Court of Appeal on Zoom. I hated it. Okay. Probably the first person to be thrown out of court on Zoom on an appeal. The other matter I was on just last week was, and this is in the field of criminal law, I was in court in Belleville, in court, so to speak. On one side, I had a client up in Almont on the other side. And actually, that court is very well run. It's very well done. But I find it awkward, and I find the feeling of making representations, unless you have a very receptive and careful judge, which I had in that case. It's just not the same at all as being face to face with the judge and being able to have that interaction. So it's got to be addressed as best we can, but it's definitely not the same. And in my view, it doesn't improve access to justice being forced into this situation at the present time, even though we obviously can't help it.
It's a very candid Len, typical and insightful. Thank you.
Yes, thank you, Len. Enoch?
Well, thank you again, Doran. I said this is a topic that really delves deeply into the heart of change as a concept and the human psychology as to how we react to change. I will know that the majority of us has been negative towards the concept, I myself inclusive. But I'll prefer to play the devil's advocate a bit as to what are the advantages of this change. Changes are very difficult thing to achieve because we are used to and we're comfortable with the way we do things. But once the adjustment is fully made over time, it becomes the new normal. There are many aspects of the change that does make sense. And there are many aspects of this change that diminish the value of the change. But I think it's here to stay. So it's the more we warm up to it, I think the better land that we are going to have. And the reason is because if we fail to do so, then our profession will be lagging behind technology. It will be lagging behind every other profession that we do have around. It means we can't sustain a second pandemic should it come across. There are a whole lot of questions, a panorama box that can be opened as to the effect it could have on our profession on the long run. So I think it's here to stay. I think we have to embrace it. I think billions have been invested into developing systems for lawyers to be able to adapt. I think that the development will be continuous and ongoing. And as much as I do dislike it, I'm warming up to the idea. So what are the positive aspects of what does change brings? It brings about greater flexibility. The fact that sometimes I don't have to go to office only on Fridays and I wake up from my bed, wash my face, and I sit with a judge and I go back to then take care of myself without having to rush and do all the struggles. It brings about flexibility, not only to lawyers themselves, to also the litigants. And from my own observations, I think that it has brought about greater participation of litigants in the court process. I was often in a position where you have made all the plans and you don't see your client in court. You can't even explain why your client is not around. But these days, there seems to be greater communication between lawyers and clients. I set up my calendar to remind me, and at the same time, I send the invite via Google to my client, so it's reminding the both of us, and we're able to even communicate like a day before the case. My clients have been more engaged. And I've had a few conversations with a few clients as to how to find the Zoom meeting. They tell me that it's more comforting to sit around family and friends, hanging all around them, and they don't feel judged. And if sometimes one told me it's like hiding behind the screen. Though she was there, she didn't really feel the impact of a court case because she's been through it before. And she didn't have to break down. She's someone who has anxiety problems. So to people who have anxiety and medical problems, it's also an advantage to them.
Yeah.
Another thing that I will add to what I've already said is that well, it updates the legal system to the standard of the current technology. And the general takeaway about the technology is that we're also able to learn how to use technology and apply the learned skills in other areas of our life. The very fact that we all seated down today over a Zoom meeting instead of in a town hall, lined up with chairs, tells you the kind of dynamism and growth, or should I say the journey we've made from what it used to be to what it is now. I think other professions are quite catching up, doing well. I see a lot of platforms selling out every day, all Zoom meetings and the rest of them. I think the legal profession should not be left behind, to lag behind. Having said so, Enoch is now speaking based on my own personal opinion. I was just being the devil's advocate a moment ago. There is one aspect of the change that I do not appreciate. That's the opportunity I've always had to walk up to people like Alison Campbell, colleagues, and try to get some ideas on how to approach a case as a new week. I think that's a lost opportunity. And sometimes you call lawyers on the phone, you can reach them. But when I have challenges as to how to approach a case, there are always lawyers around who are willing to tell you, well, I had a similar experience. This is what I did. And when you approach the case, sticking to those advice and lines, most often than not, you might find some success. So I miss that ability to get coached, especially as a sole practitioner by other lawyers, right there on your feet on the instance, and also to have the contributions of lawyers, even when you're making submissions. I think we've lost that aspect of practice. Another aspect of our practice that I think that is lost in the process is the opportunity we've always had to reconcile cases just prior to the hearing. When I have concerns regarding my case and I know I have a bad case, what I try to do is that I approach the opposing counsel to express some opinions and share my ideas on how I might move the court with regards to the case. And I want to hear his opinion as to his position. And sometimes we're able to come to an agreement on what is fair instead of arguing it before the court for the sake of argument. And most times we just adopt a joint submission to the court. We don't waste the court time and the government resources because we've already had a time prior to the court case to agree. So we've also lost that aspect. And most lawyers, when you call them, it's very hard to reach them. That's a very difficult feat to achieve. Alison emphasized picking the cues. It aggravates conflict, which is true. And I think the worst aspect of the change is the impact that it has on the older generation of lawyers. I would say the finest of the lawyers seems to be the one disadvantaged the most. So I think there has to be a long learning curve. And I think that both the bench and the bar need to be more accommodating to lawyers. It might also lead to people missing their dates more. Some people were used to keeping all their informations in their diaries. A whole lot has had to change, even in people's personal lives. We are now more electronically based and manually based on books and all that. So there's a whole lot of change. And I would hope that that the bench, that the judges are more understanding, that the lawyers are more understanding, and that we're able to cooperate and explain to our clients to also be more accommodative of one another. I think with that and with training, I think we'll be able to all adjust to the new normal and welcome it, as painful as it may be for now. So that's just my take on it.
Thank you. Thank you.